Today we will say hello to Molly. So say hello to Molly. Also, a reminder that when you speak in class, you're not speaking to me, you're speaking to Molly. So Molly, if you don't hear them, close with them now. So let's begin with the first question. Linda and Matthew, tell me, Linda and Matthew, what is the key word here? If a body accepts an offer containing an immaterial unilateral mistake, what's the key word, Matthew? What's the key word, Linda? We have a difference of opinion. So what do you think? Elaine is the key word, and tell me, Linda, what does immaterial mean? Doesn't matter. That is, it's a fact. So, and you're an accounting major, so you know you should be familiar with myself. So it means that if the fact is different, it won't change my decision. So Tellini, is the key word here unilateral, or is the key word here immaterial? Therefore, that means, Matthew, it does not make a difference. Therefore, Matthew, the answer is C. C? Valid as to both parties. Okay. Question 2. Tellini and Kobe, Tellini, tell me what's going on, and give me a description of the facts, and then Kobe, tell me who made the mistake. So Tellini, a brief summary, and then Kobe, who made the mistake?
So Miller is trying to sell his store to Jackson, and he doesn't have any financial statements ready, and so he makes out to the best of his ability and
From the checkbook.
From the checkbook, and tells Jackson that it might be a good idea to get an accountant's opinion, and not to rely on it. Well, he doesn't rely on it, but he does give him benefit. But Jackson doesn't do that, and he buys the store based on what the financial statements that Miller made, and then later he finds out that there were lots of errors in these statements, and he sues Miller basically for it.
So Kobe, good statement of facts? Good statement of facts? So who's to blame here? Is it Miller who did the financial statements, or is it Jackson who failed to get them checked? Therefore, now that Tellini, now that I know that, I think I can answer the question. Kobe, the answer is B. Jackson not prevailed because his reliance was not reasonable. Now, Tellini, if we change the facts and we say that Miller says to Jackson, this was prepared by CPA. In fact, this was audited by a CPA. Does that change the facts? Very good. Question number 3. So, Megan, tell me what's going on, and then Kelsey and Timmy answer the question.
So Smith contacted Jackson to repair his boat, and the work was supposed to begin in May, but a couple days before he was supposed to start working, the boat was destroyed by a fire, and so we're determining if there's a contract.
So Kelsey, is anybody liable? No. So therefore, that means I can eliminate answer number B and answer D. So B and D are clearly not correct. Because we can't possibly fulfill this contract because there's no boat. So therefore, the answer is either A or C. Kelsey, what do you think? Megan, what do you think?
C, because there's no
Yes.
mistake.
And in fact, there's no mutual mistake because one had no way to know that the boat did not exist. And Kelsey, it is impossible to fulfill the contract, subject matter, destruction, subject matter. Question number 4. Now, I purposely gave you this question to have confidence in you, and he's first and you're second, not confidence. And I purposely, we're going to talk about, in fact, in a minute, Alex, I'll give you an example about fraud and inducement, and we're going to talk about fraud and inducement and fraud and execution when we talk about commercial paper. But I purposely chose this question to see if we could experiment a little bit to break answer a question, well, I don't know the answer, let's see if I can reason through it. So let's do that together. Brandon, what do you think about answer number A? That the defendant was an expert. Can non-experts mislead?
Yeah.
So A's not right. So Alex, what about C? Can I mislead orally? So C's not right. And, so I think Brandon answers B or D. But I don't have to be in a fiduciary relationship to mislead somebody. And Alex, if I was a fiduciary relationship that I had, like clergy parishioner, or parent-child, or caregiver, or whatever, then it wouldn't be misrepresentation or fraud, it would be under influence. So therefore, the answer must be B. And just look at B more carefully. Brandon made the misrepresentations with knowledge of their falsity, and that makes sense. I knew it was false, and I intended to deceive. So the answer is
B.
B. Okay. Now, question number 5. David and Taylor, for a purchaser of land to avoid a contract with a seller based on duress. So let's eliminate the questions that we know are wrong. David, what about A? No. What about D? No. So the answer is either B or C. And so the question here, David, is do we look at whether do we use a reasonable person test, or Taylor, do we use a particular person? That is it a reasonable person, or is it a person who was deceived? And as a general principle, Alex, last semester, I won't mention anybody's name. The last semester, somebody said in advanced tax class that somebody was a wizard. And that person, when he heard that he was a wizard, you were a witness to that, right, Talini? When he heard that, he broke down in tears. Now, that was his reaction to being called a wizard. And I won't mention his name, David. But here's my question. Alex, would a reasonable person be offended at being called a wizard, or would a reasonable person say, oh, thank you, that's a compliment? So therefore, in tort law, we use a reasonable person test. We ask, what would a reasonable person do? In contract law, we do not. In contract law, we look at what is reasonable in business. So the reasonable person test is one of the tests of tort law. It's not, and so therefore, Alex, if this person sued whoever said this slander for intentional infliction of emotional distress, he would lose. Why, Talini? Because his reaction is not reasonable. But in this case, David, we don't look at what's reasonable in a contract law case. That's a tort principle. Therefore, David, now that I know that, I know the answer is C. Taylor, will read. Question next. Michael and question 6. Michael and Joy, Michael and Joey, I apologize because this is just the definition. No analysis involved here. We can't do analysis on every question. So, by definition, somebody is induced to enter a contract by another person because of the close relationship. By definition, that is under influence. Next time, we'll give you a more challenging question. So let's go to those for today. But before we do that, let's turn the lights off. Now let me talk about quality and inducement and quality and execution. And I'll tell you a story. Let me know what you raise. So fraud and the inducement. And fraud and execution. stories, and I want to ask you which one is fraud and inducement and which one is fraud and execution. Ready? So Alex has always wanted to own beachfront property. She always wanted to live out on the beach, go surfing in the morning and whatever else. And so I sell her some beachfront property in Arizona. Now, clearly I've committed fraud. Now, and I get Alex to sign a promissory note that says, I, Alex, promise to pay $100,000 to Alan on demand. So now I've got a promissory note. Now, clearly, Talini, I cannot enforce this. Okay? I hope not. Now, Alex is pissed off, and she says, well, I've got to pay Alan $100,000. She doesn't, but not only is she foolish enough to buy beachfront property in Arizona, she doesn't even legalize it. So then, Candace, she says, I've got to get $100,000 from somebody who can afford it. So she is a big football fan. So she goes to Tom Brady and she says, can I have your autograph? And she says, here's a football, would you sign it? He picks up the football and he says, no, that's a deflated ball, and I don't handle deflated balls. We don't cheat, I'm a patriot. And then, but she's ready. She pulls out of her pocket a piece of paper, and she folds it over double, so he can see what's on the top, and she says, can I have your autograph? He's flattered, and so he signs his name. What he did not read, Candace, is the top of the paper that said, I, Tom Brady, promised to pay Alex on demand $100,000. Now, she has committed fraud. And Taylor, her justification is, well, Alan did it to me, it's fair. Plus, I mean, is he going to miss $100,000? I mean, Michael, that's one pass. Okay, so, even if it's intercepted, so now, Linda, you've heard the two stories. And one of the things I'd like to do is I'd like to, and Linda, later when we do negotiable pay growth in a couple of weeks, I'm gonna give you these. I'm gonna ask you to define the terms and then give me these two examples back. So you remember that? Okay. Now, which one of these, what I did to Alex, was that fraud in the inducement, or was that fraud in the execution? The inducement. I used fraud to induce her to sign. You agree? So that was what I did to Alex. Now, Linda, what did Alex do to Grace? Fraud in the execution. That is, she got him to sign not knowing what he was signing. Does that make sense? And the neat thing about that is that Talini, we have given you a legal definition without having to define it because, for once, the lawyers are speaking simple English. I hope you agree. I couldn't find you over. So let's go to the notes for today. And by the way, don't you think Michael, somebody does a really good job of these PowerPoints? You don't think so? You don't like the PowerPoints? What don't you like about the PowerPoints? Colorful and okay. Sarcasm. Did the microphone pick up the sarcasm in his voice?
I don't think it did.
Next time we'll move the microphone over there. Okay. Today, Michael will wrap up our discussion of our review of contract law. Next week, in fact, Michael will be doing contract law the rest of the semester because everything's based on contract law. Beginning on Monday, we'll pick out the special rules of the UCC, but today we'll wrap up our discussion. We're talking about third parties. First, the concept of privative contract. All the original parties to the contract have rights and liabilities under the contract. Michael, that makes sense. If you and I have a contract, that has nothing to do with me. However, there are exceptions to that one of the exceptions is the assignment of rights for the delegation of duties, and also a third-party beneficiary, which we'll talk about each of these in terms of. Say it again.
I don't know.
Nope.
I don't know. I think I called you Ann.
Ann?
Yeah, I don't know.
Can I call you Miss A?
Yeah.
Can I call you Sally? Okay, Ann. Did the mic pick that up? She said no. Sells merchandise to Zenith on account and transfers the account receivable to Brandon. In this assignment, Brandon would have the same rights as Ann, and Brandon, that makes sense. Also, Michael, does Zenith care who he pays? No, it's just painful to pay one or the other. So now, Ann, if Brandon had paid you for the assignment, can the assignment be revoked? What do you think? Because now, if he pays you, and let me ask, Brandon, why would you do that? So the accounts receivables were $1,000, and it's going to be paid in 30 days. Why would you want to buy that receivable? Or, said another way, Brandon, why would she want to sell it? She's got a promise from Zenith to pay her in 30 days, but she wants the money today. And she goes to Zenith and she says, pay me, I need money desperately. He says, hey, our terms are 30 days. Now you come in because what do you have? You have money. You have money today. And so how much are you going to pay for the $1,000 accounts receivable? $1,500?
Sure.
That was even listening to the question. You would pay $1,500 for the right to receive $1,000.
No.
Okay, so you're not going to pay $1,500, right?
Right.
You're not going to pay $1,000 because that's a break-even position. You're going to pay as little as possible, maybe $950.
Yeah.
So you pay $950 today for the right to receive $1,000 in a month. Michael, is that a common commercial transaction? Okay. So, and is there a contract? You've provided him consideration that basically you've sold your accounts receivable. And Brandon, you provided consideration. You gave her cash. So, and can the assignment be revoked? No, you have a contract. You have a contract, and he has paid you for that assignment. So now you cannot get out of it. Now, if Blake, Brandon, who's Blake? If Blake received the assignment as a gift from Ann, then he revoked the assignment if Zenith had not yet paid him. I see what you mean. What do you think, Ann? Now it's a gift. Now, and Katie, last time we talked about morally corrupt people like you. For example, who negotiated with your children, God's gift to you. So I think it would be morally wrong to go back on a gift. But legally, can she? Yes. So the answer here is no. The answer here is yes. But now, Candace, suppose that Zenith has already paid Brandon. Michael, can we impose a duty to pay him to pay twice? So here, Michael, it cannot be revoked. So here it cannot. Number one, cannot. Number two, it can because it's a gift. Legally, I don't know about morally, but we don't do, this is a law class, we don't do morality. Okay. Questions? And here's a handy chart, which I'm not going to discuss, but it is a visible diagram, which I think Michael's pretty good. Assignments. Rights cannot be assigned. When the statute expressly prohibits assignment, for example, Cindy, most states, including the state of Missouri, has laws that will not let you assign away future wages. When a contract is personal in nature, Cindy, can you think about an example of that? Contract is personal in nature. Suppose that you contract with Kobe to do a portrait of yourself. You're making a face. You don't trust Kobe? Okay, Kayla, you don't want portrait of yourself, so that you can show your grandchildren what you looked like when you were young and beautiful. And I think the advantage of a portrait, I think the advantage of a portrait is he can make you, see, if we took a photograph, we can't doctor that up. Portrait, he can, okay. So Kayla wants a portrait of Peter to remember him by. So is that a contract, Kayla, that would cover number 2? Would that be something of personal nature that you cannot assign to somebody else? Yeah. Or if the assignment materially changes the rights and duties, and that makes sense. Rights that cannot be assigned when assignment which can significantly change the risk or duties. So let's think about an insurance contract. Suppose that you have car insurance, and you have car insurance with Kelsey's insurance company, and you say to Kelsey, I've paid you my premiums, and I'm a very, very good, I've been paying you premiums for 35 years, and I've never filed a claim. And Kelsey is an insurance company that's kind of applied to your life. And so then Delaney, you sell your car to Jody. And you say to Jody, the insurance goes with it. So you assigned your insurance right, your right to be covered in the insurance policy to the buyer of the car. Kelsey, you're the insurance company. What do you say about that? No way, because Jody might not be as good of a risk. So because to assign your rights in the insurance policy to another person changes the risk that the insurance company takes, so that cannot be assigned. Okay, also, it could be argued that is personal in nature. Delegation. An assignment, remember, an assignment is of rights, and delegation is of duties. Contractual duties in bilateral contract are delegated to a third party, definition. And again, a very nice line. I like this. Okay. Duties that cannot be delegated, when duties are personal in nature, when performance by a third party will vary materially from that expected by the LBV. Suppose that I hire you, Megan, I have a loan company, and I hire you to work for me. I hire you as my agent to work for me to decide who I'm going to make loans to. So you're my loan officer. And you are sick one day and say, I just don't want to go to work. And so you assign that, you delegate that duty to Brandon. Megan, can you do that? No. Why not?
I'm working for you.
And I may not have as much confidence in Brandon as I do in you. Therefore, it changes the risk that I'm taking when Brandon starts making loans to his credit card. Duties cannot be delegated where the contract prohibits delegation. If the contract says we cannot delegate the duties, you cannot. Effective delegation, the delegator remains liable unless she's released. The delegatee is liable if the delegation contract creates a third-party beneficiary relationship. Assignment of all rights. Generally, when assignment is made in a contract, the implication is assignment of all rights. Unless, Taylor, we say otherwise. So if I say to you, Taylor, I assign you my rights under my contract with Barley, if we don't specify which particular rights, I've assigned them all to. Say that again. I say to Taylor, I assign you all my rights under contract with Molly, and let's suppose I have 5 different rights. If I assign them to you, or sell them to you, or give them to you, then you pick up all the rights I have. Now, Taylor, if I don't want to give you all my rights, what do? I simply say, I assign you right number 3. So if I say I assign you my rights, that means all. If I say number 3, that means number 3, very good. However, I'm still liable for performance of the duty. Third-party beneficiaries. There are types of intended beneficiaries, a creditor beneficiary of benefits in a contract which the promisor promises the promisee. I see what you mean, Michael. Let me give you another example. Michael, let's suppose Keith Harrison is going to retire. And Michael, you know why Harrison's retiring? Financial freedom. And then if it's not finished, no.
Pretty sure he wants to do it.
My story's more interesting. Your story's true. And also, I tell you, Michael, here's something you don't know. I came to Truman in 2004, and Harrison was talking about retirement then. But he didn't put in the paperwork until 93. So, I mean, whose story do you believe? My story's more interesting. Okay, so Harrison's going to move to, where's he from? Pennsylvania, somewhere back east. So he moves to Pennsylvania, and Michael, buys a house and he takes out a mortgage. Now, just to be polite about this, he's old. And let's suppose, Cindy, let's suppose that you were the bank that loaned him the money. What are you worried about? He's going to die. And he dies, what happens? He won't pay, because dead people don't pay. So, Michael, you got the story? So, Cindy, what are you going to ask them to do about life insurance? Life insurance that would be payable to the bank if he died. Taylor, you got the story? So Harrison takes out a mortgage. And do you think, Michael, this would be common? Every mortgage situation, the bank requires life insurance. Paid by the person who took out the loan with the bank as the beneficiary. So Taylor, you got the story? Harrison takes out a loan, the bank wants protection against his possible death. He takes out a life insurance policy and names the bank as the beneficiary. So, Michael, what have we just done? We've just done a creditor contract, and we named the bank as a creditor beneficiary. That makes sense. Alex, I'm beginning to think the examples are better than this. I'll find somebody new to do. Example. Donee beneficiary. And in fact, Michael, what's the word? Were you in tax research last semester? Linda, you were in tax research, so you know all about gift tax. You know what a donee is. Donee is the person who receives a gift. So donee beneficiary, and Linda, by naming it, we sort of defined it. A donee beneficiary is a third party who has been made a gift. Contract is made for the express purpose of the promisor giving a gift to a third party, who are called the donee. Donee can sue the promisor directly if the promisor breaches the contract. So Talini, we started today by saying that the general rule is that if I have a contract with you, that has nothing to do with coding. But now we've looked at exceptions, and one exception is assignment of rights. Second exception is the delegation of duties. And the third one is intended beneficiaries. We talked about the creditor beneficiary in the case of the bank. Now we'll talk about the donee beneficiary. So let's do some examples. AJ has a contract with DU. Say your name. Say it loudly so I can pick it up. Did you? To build a house for AJ's son, Kobe. David was the next door neighbor. So who can enforce the contract? AJ, can you enforce the contract? Yes, why? You have to put it in legalese, you have privity of contract. You're one of the original members. Kobe, can you enforce the contract? Now, Kobe, you don't have privity of contract, do you?
No,
But can you enforce the contract? Why?
because it's house
It's for you, and so you are an intended domain beneficiary. Now, David, arguably you would benefit, and I should add to this, AJ, this is gonna be $1 million house, because you got money. So why are you here? If you got money, why are you here? In fact, you know what you should do? I'm so impressed with your performance in this class, why don't you take Monday off?
All right, thanks.
That's our agent. So David, if you live next door to Kobe, you would benefit from somebody building $1 million house next to you. Is that right? Property value. So therefore, you are a beneficiary of this contract, but you're an intended, unintended beneficiary. Which means that AJ can enforce the contract because she has privity of contract. Kobe, you can enforce the contract because you're a donee beneficiary. David, you cannot. So many of you will remember in legal environment business, we did a case where an uncle bought a car for a nephew. And remember, in legal environment, there were a lot of generations of uncles. Uncle bought a car for a nephew, and it's supposed to be delivered to Truman, to Cooksville, in August, so that the nephew would have it when he starts to school. And so the contract, Kelsey, is with you, and it's with the uncle buying a car for his nephew, and you're supposed to deliver it to Truman in August. You don't. Now, who can sue you? Can the uncle? Because he's privy of contract. Can the nephew? Yes, because he's a donee beneficiary. What about the nephew's girlfriend? Let's think about that. Taylor, would the nephew's girlfriend benefit from the nephew having a car?
Yes.
Sure. But could she sue? Why not? She's unintended, accidental, I think is a better term, but the legal term is unintended. So, the final slide is, final two slides, is a nice little graphical representation of intended and incidental beneficiaries, which Michael has already summarized. And then, I'm really interested in concept summary of the assignments and delegations. Michael, what do you think we took this from? Out of the textbook, which you don't really have those chapters. I don't know. Michael doesn't, Michael, I think is a tough customer. And he doesn't like the PowerPoint. Taylor, what do you think? You know who does the PowerPoints? And doesn't she do a good job? See, now don't you feel bad? Let's look at the last slide. Oh, we'll do this a little bit.